But the case is listed in item 197. And it is increasing. So we can take up my lord.
He beg pardon, my lord. Matter relating to Surface Act rules made there. My auction property is put to auction today, my lord. My lord, tomorrow may be taken. Obligers.
Item 156. This is a matter where on 3 occasions the state had taken time just to ascertain whether similarly placed person has been granted pension or not. And since February, this matter is on the last occasion your lordship had granted a week's time. That was last week. The matter was listed. It did not reach. The man is without a pension since 2022 after rendering 27 years of service. May I only pray 136 be taken up today, tomorrow, subjecting instruction today.
Yes, we'll see that.
Item 226 of the cause list is a matter related to the examination of the judicial service. The matter will become infructuous because my lord has directed to obtain instruction. It will become infructuous. I pray that
18. There is a mistake in the writ petition. I have filed the writ petition. Annexure 1 is the entire original application filed before the tribunal. It carries 16 annexures. By mistake, 12 annexures are there. If your lordship may grant me 1 week time, I'll rectify the mistakes.
You want to withdraw?
No. I want your lordship may kindly grant me 1 week time so that I can replace that annexure 1, entire annexure 1.
You want adjournment?
Yes, my lord. Next week, any day.
All right, Mr. Bimbisar and senior panel counsel item 6 for an adjournment for 1 week. Put up this matter. Right. Yeah.
Would your lordship be kind enough to observe that I want to replace annexure 1?
Whatever you want to just do it.
I can mention your lordship. Lordship, item number 188, 189, your lordship, where the petitioner is challenging the selection list of the OCHS 2022. Lordship, it may be taken up in the supplementary list or next week, because it will become infructuous because 23-24 exams have been conducted already.
No, pardon, madam. Item 206, my lord. I have mentioned several times.
Please call the
Item 77, my lord. The last week also I have made it. No, what happened here? There are 3 matters. In first matter, IA has been filed. That will be taken up in orders, my lord. It is in the admission list, so therefore it is going down.
All the matters. Please, item number.
Weekly list. Lordship, I may be permitted to make a mention. Lordship, item number 202 of the item number 1.
Union of India has filed this writ application, my lord. Challenging the order of tribunal, my lord.
Very good, man. Why are you sitting in the back?
The Union of India has filed this writ application challenging the order of tribunal, my lord. What happened? Lordship kindly have
Use the mic properly.
The Union of India has filed this writ application challenging the order of tribunal at Annexure 4, page 109, my lord. Here, my lordship kindly have a glance to page 116, last portion of the order.
You are challenging Annexure 4.
Annexure 4, my lord. Page 109.
Please come to the prayer.
My lord.
Please come to the prayer.
My.
Page 8.
My lord.
Questioning
the order dated 15/9/2023, passed by the Land Central Tribunal, Cuttack in OA number.
Now you come to Annexure 4.
Annexure 3. Yes, Annexure 3, my lord. Sorry, Annexure 3. Annexure 3 at page 108. Lordship, kindly have a glance to paragraph number 10. Here, within 60, the prior, the opposite party has filed the writ application challenging the order of recovery. His prayer has been allowed, and here the Union of India is directed to pay that recovery amount within 60 days. This order was passed on 8/2023, my lord, August 2023. So 60 days period has already been expired. May I pray 1 and 2, both these matters are interlinked. May I pray this matter may be taken up next week so that I will obtain latest instruction whether this amount has been paid or not, because in the meanwhile 1 year has been passed. By virtue of a writ application, he has been reverted to a post. Subsequently, he has filed the original application, and because of the original application, reversion order was passed, and subsequently the excess amount which has been paid, that has been as per the reversion order, recovery was made to the tune of 60,000 some odd amount.
So the operative part of the
Yes, paragraph 14, my lord.
Paragraph 14. The respondents are directed to refund any amount recovered
from the applicant within a period of 60 days. However, the prayer of the applicant from grant of difference.
So you want just to obtain instruction whether this amount has already been recovered or
no, this already recovered, but already refunded or not?
64 left, 64,000.
64,000.
All right. Item number 1 shows this Union of India has filed this writ application challenging the order dated 15/9/2023 passed by the Central Administrative Tribunal Cuttack in OA number 128 of 2022 under Annexure 3. In the operating portion of the improved order in paragraph number 14, the petitioners were directed to refund any amount recovered from the opposite party within a period of 60 days, inter alia with other orders. Mr. T.R. Gupta, Central Government Counsel, appearing for the petitioners, seeks for an adjournment for 1 week to obtain instruction as to whether the amount in question has already been refunded to the opposite party or not, since 60 days have already been passed since the date of the order put of this matter on such and such day. Similar order is to be passed. Item number 2.
Theoretically, amount of 1,57,000.
We are not mentioning any.
Mile.
Item number 3.
You did not produce the original death certificate of your husband on the date of scrutiny.
My case is that, my lord, I produced the original certificate, but they did not take into consideration.
No, that is the noting you did not produce.
And lordship can see
and, this advertisement in page number 13. I do not using that. See now. This page number 13 person. Page number 13 ର
My lord.
last paragraph ଟାକୁ ଦେଖ
Yeah, Lord.
ପଢନ୍ତୁ ଏଟା।
My lord. ପ୍ରାର୍ଥୀ ମାନଙ୍କ ଠାରୁ ପାଇଥିବା ଦରଖାସ୍ତ ଗୁଡିକ 18/11/2021 ତାରିଖ ଦିନ ଚୟନ କମିଟି ଦ୍ୱାରା ରଘୁନାଥପୁର ଶିଶୁ ବିକାଶ ପ୍ରକଳ୍ପ ଅଧିକାରୀଙ୍କ କାର୍ଯ୍ୟାଳୟ ତନଖି କରାଯିବ। ଉକ୍ତ ଦିନ ସକାଳ 10 ଘଟିକାରୁ ଅପରାହ୍ନ 5 ଘଟିକା ସମୟ ମଧ୍ୟରେ ଆବେଦନକାରୀ ପ୍ରାର୍ଥିନୀମାନେ ସେମାନଙ୍କର ମୂଳ ପ୍ରମାଣ ପତ୍ର ସହିତ ଅତ୍ର କାର୍ଯ୍ୟାଳୟରେ ନିଜେ ଉପସ୍ଥିତ ରହି ମୂଳ ପ୍ରମାଣ ପତ୍ର
ପ୍ରମାଣ ପତ୍ର ମାନେ original death certificate. So the mark which you are claiming, that is 10% extra mark, 10 extra marks, that is because you are a widow, right? But you are supposed to produce the original death certificate, which you did not produce on the date of scrutiny.
Lordship, you can see the next sentence of that advertisement. ନିର୍ଦ୍ଧାରିତ ଦିବସରେ ମୂଳ ପ୍ରମାଣ ପତ୍ର ସହ ଯାଞ୍ଚ କରି ନ ପାରିଲେ ତ ଦରଖାସ୍ତକୁ ବିଚାରକୁ ନିଆଯିବ ନାହିଁ। Had I not submitted the original, verified the original death certificate, my application must have been rejected. But they have not. They did not reject my application. Rather, they did not award marks for the death of my husband.
No. That mark has not been added. Otherwise, you would have been qualified. ଆପଣଙ୍କୁ ଯେ 10 ମାର୍କ ଦିଆଯାଇଥାନ୍ତା ତାହେଲେ ତ ଆପଣ ସିଲେକ୍ସନ ହେଇଯାଇଥାନ୍ତେ। ସେ 10 ମାର୍କ ଏଇଥିପାଇଁ କଟା ହେଲା ଯେ ଯେହେତୁ ଆପଣ ବିଧବା ମାନଙ୍କୁ 10 ମାର୍କ ଦିଆଯିବ ପ୍ରୋଭାଇଡେଡ ଦ୍ୟାଟ ଦେ ପ୍ରଡ୍ୟୁସ ଦି ଡେଥ୍ ସାର୍ଟିଫିକେଟ। ଆପଣ ଯେହେତୁ ପ୍ରଡ୍ୟୁସ କଲେନି ଆପଣ ମାର୍କ ରହିଗଲା 59 ନା କେତେ ରହିଛି।
ନାଇଁ ସବୁ ଏଟା ହଉଛି ମୂଳ ପ୍ରମାଣପତ୍ର ଅଲ୍ ଦି ଅରିଜିନାଲ ଡକ୍ୟୁମେଣ୍ଟସ ଦ୍ୟାଟ ଆଇ ହାଭ ସବମିଟେଡ। ମାନେ ମ୍ୟାଟ୍ରିକ ସାର୍ଟିଫିକେଟ ରେସିଡେନ୍ସ ସାର୍ଟିଫିକେଟ ସବୁ
ଯୋଉ ଡେଥ୍ ସାର୍ଟିଫିକେଟ ଟା ଅନଲାଇନ ରେ ଅପଲୋଡ କରିଥିଲି ତେଣୁ ସ୍କ୍ରୁଟିନି ଦିନ ଏଇ ଆଡଭର୍ଟାଇଜମେଣ୍ଟ ଅନୁଯାୟୀ ଆପଣଙ୍କୁ ଅରିଜିନାଲ ଦବା କଥା ଆଉ ଅଥରିଟି ମେନସନ କରିଛନ୍ତି ଆପଣ
ଆଇ ହାଭ ନଟ୍ ସବମିଟେଡ ଦି ମାଇ ରେସ୍ପେକ୍ଟ ଫର ସବମିଶନ ଇଜ ଦ୍ୟାଟ ମାଇ ଲର୍ଡ ଏଇ ଯୋଉ ଲାଷ୍ଟ ସେଣ୍ଟେନ୍ସ ନିର୍ଦ୍ଧାରିତ ଦିବସରେ ମୂଳ ପ୍ରମାଣ ପତ୍ର ସହ ଯାଞ୍ଚ କରେଇ ନ ପାରିଲେ ଯଦି ମୁଁ ଫେଲ ମାନେ ଯାଞ୍ଚ କରେଇ ନ ପାରିଥାନ୍ତି ତାହେଲେ ମୁଁ ମୋର ଆପ୍ଲିକେସନ ରିଜେକ୍ଟ ହେଇଥାନ୍ତା।
You are bringing us to adjudicate a disputed thing. Authority କହୁଛନ୍ତି ଆପଣ produce କରିନାହାନ୍ତି ଆପଣ କହୁଛନ୍ତି ମୁଁ produce କରିଛନ୍ତି। So for that evidence is required. We cannot enter into that in a writ petition.
The appeal, my lord, but before the ADM also held that I have produced and that is why ADM allowed my appeal and
that was set aside by the single and single.
Yes, my lord.
That order you are infusing.
And that apart, my lord, you also can see, my lord.
ଆପଣ ଯଦି ପ୍ରଡ୍ୟୁସ କରିଥାନ୍ତେ ଅଥରିଟି ମାନଙ୍କର କଣ ଆପଣଙ୍କ ବିରୁଦ୍ଧରେ ଯିବାର ଥିଲା ତାହେଲେ ତ କିଛି there is no malified attributed against the authority ଯେ ଆପଣ ତାଙ୍କ ପାଖରେ original death certificate ଆପଣଙ୍କର husband produce କଲେ deliberately ତାକୁ notice କୁ ନେଲେ।
They are saying that two things, ମାନେ xerox ମୁଁ upload କରିଛି ଏବଂ original ମୁଁ show କରିପାରିଲିନି। xerox ଟା upload ମାନେ it will be uploaded from the original.
Copy ଟା xerox ର evidentiary value ଯାହା ହବ that's a different matter.
Yes.
But original ଯୋଉଠି ଲେଖା ହେଇଛି ଯେତେବେଳେ ବି ଆପଣ କୌଣସି ଅନଲାଇନ ଆପ୍ଲିକେସନ ଦିଅନ୍ତି ultimately ଯେତେବେଳେ final selection ହୁଏ ସେତେବେଳେ it is required that you should produce the original one. If you fail to produce, obviously your candidature will be rejected and you cannot be considered. What fault lies with the authority?
My case is that ମୁଁ ଯଦି ନ ଦେଇ ପାରିଥାନ୍ତି ଯାଞ୍ଚ କରି ନ ପାରିଥାନ୍ତି ତାହେଲେ ମୋର ଆପ୍ଲିକେସନ
ଆପଣ ଉଲ୍ଟି କରୁଛନ୍ତି you are going in the other way round.
ଆପଣ ତ କଲେ ନାହିଁ ଯୋଉଟା ରିକ୍ୱାରମେଣ୍ଟ ଆପଣ କଲେ ନାହିଁ ନ କରିଥାନ୍ତି
ମାନେ my submission is I have read. And besides that, your lordship can see prayer made in the writ petition.
If a particular rule is prescribed, you have to opt it in the same. You cannot make a different way.
The authority cannot, as my esteemed brother say, that the scrutiny requires verification of the original documents.
Yes.
So that is the prescribed procedure. So can the authority, whosoever it may be, go beyond that procedure and formulate their own procedure, which is not there, which is not in consonance with the advertisement. अच्छा हाँ ठीक है जी तुम produce करना हम तुम selection कर दो चु तुम कौन कोच हजी आई ची आसंदु वर्षे पर देखियो आती तो मैं आगे चाकरी नहीं जाओ।
2016 रे डेथ
ହେଇଥିଲା टाइप रो कहउछन ना
2016 रे
अपन बार जदी थिला ओरिजिनल दा प्रोड्यूस करलेनी कोन पाए who knows that it may be a fabricated one
in the year
अपन जदी ओरिजिनल न प्रोड्यूस करले Xerox copy evidentiary value is high. Maybe that it is a fabricated document.
No, Lord. You know,
ଆମେ ବର୍ତ୍ତମାନ ଆପଣ ଗୋଟେ ସବୁ ଗୁଡାକ ଡିସ୍ପ୍ୟୁଟେଡ ଜିନିଷ ଆଣୁଛନ୍ତି ଯେ ମୁଁ ଫାର୍ଷ୍ଟ ଥିଙ୍ଗ କହିଲା ମୁଁ ପ୍ରଡ୍ୟୁସ କରିଛି ଦ୍ୱିତୀୟରେ ଆପଣ କହୁଛନ୍ତି ଯଦି ବି ମୁଁ ପ୍ରଡ୍ୟୁସ ନ କରିଛି ତାହେଲେ ଏମିତି କରିଥାନ୍ତେ you are not sure whether you produced
my
or not.
case, my lord, all along with that before the ADM is also before almost single judge that I have produced the original death certificate, but they have not taken into consideration. And you know, kind of prayer made in the writ petition.
And that lady must have been appointed since 2021. She must be continuing in that.
No. She 1 month continue kala I the ADM allowed my appeal. I continued for 2.5 years. I continued for 2.5 years. Now, my lord, by virtue of the order of honorable single judge, my lord, appointment was passed on 9/8/2024. Just now, but I continued for 2.5 years.
So, what is the perversity in the order of the Learned Single Judge? Come to the operative part, that is.
May I draw your attention, my lord? You also can't see the prayer made in the writ petition.
Come to paragraph number 11 of the Learned Single Judge order. Paragraph 11. Oh, why are you sitting there?
My lord. May I read one?
Yes, please.
Reading of the impugned order reveals that a stand was taken on behalf of the opposite partner.
Now you sit. Whenever the counsel is facing difficulty, please come quickly to assist him. That is the purpose for which you are there. Yes.
Reading of the impugned order reveals that a stand was taken on behalf of the opposite partner 5 that the Xerox copy of the death certificate was uploaded along with the online application form and the original was produced at the time of verification. This is contrary to what the selection committee has endorsed in the attendance sheet, tabulation sheet, and in its minutes on the meeting. Obviously, no malafide can be attributed to the members of the selection committee so as to even imagine that they would have deliberately and falsely mentioned that the original certificate was not produced before them. The ADM has further observed that during hearing, the petitioner, opposite partner 5, showed the original death certificate of her husband, assuming that she did. In the absence of plausible explanation being offered as to why the same was not produced earlier, if it was in her possession all along, such observation of the ADM can have no sanctity. Obviously, the ADM has no power to relax the terms and conditions of the advertisement, which mandate and that the original certificate ought to be produced by 18/11/2022. The opposite partner 5, for whatever reason, chose not to produce the original certificate on the specified date. As such, her candidature was rightly discarded.
ଆପଣ ଏଡିଏମ କୁ ବାହାର ପ୍ରୋଡ୍ୟୁସ କରିଦେଲେ ଏଡିଏମ ଥିଲେ ଠିକ ଅଛି ଥିଲା ଆଉ ନ ପ୍ରୋଡ୍ୟୁସ କଲେ ଚଳିବ ଆପଣଙ୍କର ଅପିଲ ଆଲାଉ କରିଦେବେ.
You see in your WPC 5531 running page 49 where the ADM has passed the order. The order goes like this. During hearing, it was pointed out by the learned advocate for the petitioner that the petitioner has given the Xerox copy of the death certificate of her husband during online application and the original death certificate was produced at the time of verification. But the selection committee ignored the selection of the petitioner and selected the present opposite party number 3, namely Smriti. If the selection committee had taken into consideration the death certificate of the petitioner's husband, then the petitioner could have got 10 marks. Where from this came? Whereas the CTPO is saying, the opposite party number 2, who is present during hearing of the case, stated that since the original death certificate of the husband of the petitioner was not shown at the time of verification, the petitioner has not been awarded the extra marks. So where from this ADM come, and at that stage if you file the original, how can it be? A procedure has been laid down and advertisement has been floated, basing on which you have to act, because the authority cannot go beyond that.
The husband of the petitioner died in the year 2016, and in 2021, the advertisement was made, my lord.
So it was in your position.
My lord.
It was in your position. Any other ground? She belong to that area or not? Any other? No. Everything is all right. There is no problem.
And that lordship can see the prayer made in the writ petition. Only lordship kind attention.
order. Then after this court's order, you were
now my decision is
so when you were taken.
I was
Where is
appointed.
the government? Let us see.
The petition itself he has. Recap.
କିଛି ନାହିଁ ତ ଗଭର୍ଣ୍ଣମେଣ୍ଟ ନାହିଁ ଟୋଟାଲ ଆପଣଙ୍କୁ ନିଆ ହେଇଥିଲା ପୁଣି ସିଙ୍ଗଲ ଜଜଙ୍କର ଅର୍ଡର ପରେ ଆପଣଙ୍କୁ ବାହାର କରି ଦିଆଗଲା
Lordship kindly see. Lordship kindly see. Paragraph my lord 6.
Read appeal paragraph 6.
My lord.
Let us see. Read that paragraph.
That the appellant appeared in response to the notice issued by this honorable court in WPC number 5531 of 2022 and filed her counter stating inter alia in response to the advertisement at 2/11/2021. She submitted her application through online on 16/11/2021, attaching required documents, that is residence certificate for residence proof, HS certificate for proof of date of birth, the death certificate of her husband, certificate issued for ID proof, affidavit dated 15/11/2022, Aadhaar card, and her signature. She has also further stated in the compliance to the letter dated 18/11/2021 of respondent number 4, the appellant submitted all the original documents and which was verified by respondent number 4 for processing the selection process. Though the original death certificate of her husband was verified.
Last line upon election.
Last line. Last
in
line.
compliance to the direction is so and so. So what is that order? 8/3/22 ରେ ଆପଣଙ୍କୁ ଏନଗେଜମେଣ୍ଟ ଦିଆ ହେଇଥିଲା ପୁଣି ଡିସଏନଗେଜମେଣ୍ଟ କରି ଦିଆଗଲା.
That order, my lord, is annexed to the petition.
କାହିଁ ଦେଖୁନ petition ର ଅଛି. Is it annexure C/5 or what?
C/5.
Counter to the counter.
C/5 next to hand over charge to disengage reliance.
Continuing
Counter C by 5 minutes, like 17.
Right. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. And counsel for the state accept notice in behalf of the respondents number
1 to 4.
1 to 4. Requisites for issuance of notice, extra copy to be served. Requisites for issuance of notice on respondent number 5, speed post proof of delivery, certified within 1 week. Matter to be listed 4 weeks out. You have already been removed.
They have, and I have filed
application the notices.
this case, my lord,
Miscase for what?
Dismiss notice, sir.
You have already been removed.
Miscase for what?
May I pray, my lord, one thing, my lord. I have quoted the prayer made in the writ petition. The prayer is something different which is allowed by a single judge. Plus, you can see the prayer made in the writ petition. I have quoted, my lord, in my writ appeal. Yeah, notice, sir. Plus, you can see paragraph 3, my lord. Paragraph 3 of my writ appeal, my lord. The prayer I have quoted, prayer, my lord, made in the writ petition. May I plead, my lord?
Paragraph 3.
Paragraph 3 of my writ appeal. At the respondent number 5 approved this annual report in double page number 5531 of 2022 with the following prayers. Under the circumstances, it is therefore humbly prayed that to admit this writ application and shall be pleased to issue notice to the opposite parties as to why the writ application shall not be allowed. If the opposite parties fails to file their show cause or files insufficient cause, this shall be pleased to quash set aside the order dated 28/1/2022 by the Annexure 10 and to direct the appointment of 1 to 4 to allow the prisoner to discharge her duties as Anganwadi worker at a Redua Co-Anganwadi Center. And in fact, the advertisement was made for Gopalpur Co-Anganwadi Center. Plus, you kindly have a glance.
Item number 4.
Just on 13/8, I have been decision based.
May I please, Your Lordship? The petitioner has filed this writ petition, my lord, against the order passed by the DRT Kolkata, my lord. The DRT Cuttack has allowed my securitization application. Thereafter, appeal has been preferred by the auction purchaser as well as the bank, my lord. And the appeal has been
So 1327 days delay.
the appeal has been allowed. The DRT has allowed my application and it has been adjudicated finally.
I think against that order, they
Preferred, and it has been on the ground of only delay. It has been
it's all
dismissed.
right. And in the meantime, what has happened?
My lord,
ଆପଣଙ୍କର ଯୋଉ ଡିଲେ ଫାଇଲ କଲେ ଆପ୍ଲିକେସନ 17 ଭିତରେ କେତେ ଜିନିଷ ହେଇଗଲା ତା ଭିତରେ
ଆଜ୍ଞା,
ସେଲ ନୋଟିସ ଇସ୍ୟୁ ହେଇଗଲା
ଆଜ୍ଞା,
ଅକ୍ସନ ସେଲ
everything has been adjudicated by the DRT Kolkata.
you are in custody.
Yeah, my lord.
Custody, then you came out.
Yes,
Till then you also did not take step.
Now thereafter immediately filed the
Almost 4 years.
Yes, ma'am.
So,
The DRT has allowed the petition. First delay application was allowed. Thereafter hard on merit, and the essay was allowed on the ground that the valuation has been made not as per law, and no notice has been served on the petitioner, my lord. Thereafter, the appeal has been filed, and appeal has been adjudicated on the ground of delay only. Though there is merit in the case, my lord, may I submit one judgment in the similar aspect by the
recent judgment is that once this process has started, notification has started, you are over. You cannot charge.
And that is Salary LLP. I have quoting. Here is a case where the dispute which has been raised before the DRT is in respect of valuation and other respect, and it has been held by the DRT. Valuation has not been done properly.
And even if you are in custody, that cannot be a ground to condone the delay for some time, for about 1 year or 2 years.
And that is
but the delay is for about 4 years. So how do you explain it?
Delay because you are.
And in the meantime, everything is over.
Yes, my lord.
Sale certificate
that has been
must have proceeded with that. So
that has been stated before the DRT. At that point of time, the judgment was not there, and for that reason, it has been allowed, and it has been the adjudication has been made, and on the ground of valuation, which has not been done, though the sale deed has been registered in the higher price, and the valuation has been made in a higher price, but the sale has been made in lesser price. For that reason, it has been held.
Are the learned counsel for the petitioner, learned counsel for the state? The petitioner. as challenged the order dated 5/9/2023 of the Land and Debt Recovery Appellate Tribunal, Kolkata, in appeal number 41 of 2020. Your appeal is 41 of 2020.
Four appeals has been filed out of one essay.
Appeal number 47 of 2000.
All appeals has been filed by
appeal number 51 of 2009 and appeal number 29 of 2019. And thereby directing the opposite parties comply the order dated 27/4/2019 passed by the Land and Debt Recovery Tribunal at Qatar in surface eye application, that is essay number 3 of 2019. It appears that the petitioner approves the Land and DRT Qatar challenging the auction sale notice issued by a respondent. This is which opposite party number 1 under section 13(4) of the Surface Eye Act. And what is the case number that was registered as?
Registered as essay number
Which was registered as essay number
3 of 2019. It was filed in 2017. It was registered on 3 of
2019.
Sorry. Judgment dated 27/4/19.
It was registered initially as DY number.
DY number, yes, in 2017.
DY number 745 of 2017, because there was some defect.
No, delay for on the ground of delay.
On the ground of delay.
Unless until the delay is confirmed, it cannot be numbered.
One MA number 1162 of 2017 was filed for condonation of delay in filing the surface eye application. It appears that there was delay of 1327 days in referring the application under section 17 of the Act, and the Land and DRT Qatar, as per the order dated 10/1/2019,
page 97. Delay condon page 97 is the operative part.
Yes. Has been pleased to hold that the primary function of the court is to adjudicate the dispute between the parties and to advance substantial justice. The time limit fixed for approaching the court in different situations is not because on the expiry of such time bad cause would transfer into good cause, and the object of providing legal remedy is to repair the damage caused by reason of legal injury. And if the explanation for condonation of delay does not malafidness or is not shown to have been put forth as a part of dilatory strategy, the court must show utmost consideration to the suitor. Accordingly, the DRT allowed the MA number 1162 of 2017 and condoned the delay in filing the appeal and directed the registry to register the essay and thereby essay number
3/2019
3 of 2019 was registered.
and disposed upon 27/4/19.
The essay number 3 of 2019 was disposed of on 27/4/2019
Yes, ma'am.
and
Operating patch is 140.
the auction sale notice conducted by the bank in favor of the opposite party's number here is
Here, my lord,
the
2 to 6. 2 to 6.
2 to 6.
Here also 2 to 6.
2 to 6 and the notices under section 13.2 and 13.4 and the sale notice were quashed and the amount deposited by the auction purchasers, that is opposite parties number 2 to 6, were directed to be returned with interest at the fixed deposit interest within 30 days and the petitioner was petitioner or petitioners?
Petitioner.
Petitioner was directed to pay the total auction amount along with interest, cost and expenses as per the calculation of the bank within 3 months from the date of order. And the bank was directed to supply the details of the amount to be paid by the petitioner within 30 days from the date of the order. And the petitioner was directed to pay the said amount within another 2 months from the date of receipt of the calculation sheet from the bank. And the bank was further directed to deliver all the documents after receipt of the amount from the applicant. The order was challenged before the Debt Recovery Appellate Tribunal at Kolkata, which was registered as appeal number 41 of.
My lord, may I clarify here, my lord?
Here,
appeal number 41 has been filed against the interim order. The rest of the appeals against the final order, my lord.
It appears that appeal number so and so was filed before this one so challenging the order passed by the line
on 10/1/2019
1162 of 2017
Aye.
arising out of DY number 745 of 2017 and the appeal numbers 47 of बाकी
order सब final order against
and
27 order against
the appeal number so and so were filed challenging the order dated so and so passed in SA number
3 of 2.
The London Appellate Debt Recovery Appellate Tribunal found that there was a delay of 1327 days in preferring the application under section 17 of the Act before the DRT. And after disposal of the MA, no notice has been issued to the auction purchaser, who could have, that is opposite parties number 2 to 6, who could have appeared and contested the matter.
That is not correct because they have contested.
Now we are recording the London Appellate Tribunal has been pleased to hold that the statutory period for filing application under section 17 of the Act is 45 days. And the case of the petitioner was that he was in judicial custody for which the delay occasioned, and judicial custody from 14/9/2014, and he was released
on
23/11/2016, for which the delay occasioned in filing the essay on 12/12/2017. The London Appellate Tribunal also took into account that in the meantime, the surface proceeding has been concluded. Self-certificate was registered in favor of the respondent number 2 to 6. And there is nothing in the application filed for condonation of delay that no notice was ever served upon him, and that he had no knowledge even after publication of the notice made under the Act. Therefore, cannot be said that the petitioner was not having knowledge of the surface proceeding drawn by the bank. It was further held that the London DRT was under an obligation to find out whether the grounds taken by the surface applicant are supported by the material available on record. But without assigning any reason for condonation of delay, the MA was allowed, which was an erroneous exercise of power by the London DRT. Accordingly, the Appellate Tribunal was of the view that the surface applicant has miserably failed to make out any ground for condonation of delay in filing the application under section 17 of the Act, and therefore the order passed by the land DRT was set aside. And the impugned order that is dated 10/1/2019 was set aside, and MA number 1162 of 2017 filed by the Counsel was by the petitioner was also dismissed. The land counsel for the petitioner, Mr. Biswal, submitted that the land DRT has assigned cogent reason for condoning the delay, and therefore the land appellate tribunal was not justified in setting aside the same. Admittedly, there is delay of 1327 days in preferring the application under Section 17 of the Act. Even though it was the case of the petitioner that he was in judicial custody from uh, 14/9/2014 to 23/11/2016, but when the essay was filed on 12/12/2017, there was more than 1 year of delay after the petitioner was released from the judicial custody. No explanation has been forthcoming in the MA, which was filed for condonation of delay. Moreover, in the meantime, the surface-side proceeding has been finalized and self-certificate has been issued. In the case of so-and-so, which was recent decision by Justice Chandra for the reimbursement. Therefore, we find that the land appellate debt recovery appellate tribunal was quite justified in passing the impugned order. Accordingly, we don't find any merit in the petition, which is accordingly dismissed.
One submission on mine may be recorded in manner. I pray. That is, by the time the case has been disposed of on merit by the DRT court, which has been challenged, and that has not been taken into consideration while disposing the matter also.
Yes, next.
Item number 5.
I'm for the opposite party.
Anybody is appearing for the
Yes, last time he was there.
last time it was also 10/9.
Mr. Pari.
Mr. Padi?
Yes, my lord. Sorry. Item 5. Can it be taken up 30th or next Monday or Tuesday?
Also, the mention is made on behalf of the Land Deputy General India, Mr. Padi, for urgent meeting next week. Let this matter will be commencing from 30th of September 2020. Land Counsel for the opposite parties present. Yes.
Next week, my lord.
Next week, 30 तारीख.
Item number 6.
May I please, your lordship?
Yeah.
The petitioner challenged the rejection of his rehabilitation assistant application by the page number annexure 6 is the rejection order by the.
No, you have to file some application.
Yes, I have filed the documents along with the amendment petition. I have also filed, your lordship. Your lordship has allowed my IA for amendment of the writ petition along with.
No, you when the matter was taken up last time.
Yes, your lordship.
that is on 27/8/2024.
Yes, Your Lordship.
You took time to file an interim application for amendment of the writ petition.
Yes, Your Lordship.
And we said that if the same is filed, it should be kept on record.
And amendment also allowed by Your Lordship.
What is that?
Yes, Your Lordship. That is IN number, Your Lordship. IN number.
Any order has been passed after 27/8/2024.
Yes, Your Lordship. That is 11839 of 2024. That amendment petition has been filed by the petitioner, which has been
27/8 पर कौन order pass है?
10-9.
10-9. 27/8
Yes.
10-9.
10/9.
10-9, Your Lordship, was allowed.
Wait, it is not. कौन सा इसे करना? Last order from a scanning purchase of order pass is so having filed consolidated.
Yes, Your Lordship. I have filed. I have filed on 17/9/2024, and it has been noting in the writ petition also that cause title.
Petition has been filed.
File record is
Copy देना दिया कौन?
नहीं, copy भी दे दीजिए. That receipt is with me, Your Lordship. Consolidated writ petition I have served.
Where is the consolidated?
Yes.
No, that is the Prathamata consolidated writ petition.
On 17/9 I have filed, Your Lordship. Yeah, this is actually 17/9
Just a minute. Fine. Consolidated writ petition filed with lechala noting that. କାହିଁ ସେଟା? ଏଥିରେ ତ ସବୁ ଅଛି କିନ୍ତୁ ସ୍କାନିଂ ହେଇନି ନା. What is the purpose? Why the team is there? Resignation people over there. केवे फाइल कले कंसोलिडेटेड ये
17/9/2024, Your Lordship.
तेरा काइंड तो तन्नोर फाइल ला स्कैनिंग इन so the copy it will come next week.
Yes, Your Lordship.
It appears that the order number order dated who ordered
So please no 7-9.
10-9.
10-9.
10/9/2024 passed in IA number
11839.
11839 of 2024. So also the consolidated writ petition has not been scanned. The registry shall do the same immediately. The land counsel for the state submits that he has not received the copy of the consolidated writ petition. Let a copy of the same be served on the land counsel for the state during the course of this week. Matter registered on 30th of September 2024. The order to pass which he let in here. Yeah, it should be done today, sir.
Obliged, Your Lordship.
Item number 7.
Item 7 may please, Your Lordship.
You use that.
The petitioner before Your Lordship challenges the demand notice issued by the G Department.
It was on
Annexure 5, Your Lordship.
3/9/2024. It was before another bench.
My Lord, due to the change of assignment,
Acha.
this matter, and it was brought to the knowledge of the court by the
Okay, so what is your challenge here?
challenge. The petitioner challenges the demand notice under Annexure 5, Your Lordship, at page 24. This demand notice was issued by the GA department, my lord. Your Lordship may have a glance at Annexure 5, page 24. In inviting a reference to the subject cited above, I am directed to say that on perusal of the connected documents placed in the file and documents given by you, it is found that the consent fee has not been realized in the first transfer, that is between Srimati Pratima Jena and Dr. Ashok Kumar Jena. Therefore, as per this department letter number so and so, you have to deposit a sum of rupees so and so, my lord. The fact is, my lord, it's a lease property given by the G department to one Srimati Pratima Jena. Subsequently, it was transferred in the name of Dr. Ashok Kumar Jena. In 2015, under Annexure 1, the plot was transferred. The land
Pratima Jena ko ke behela kon?
Pratima Jena, that is not with me. That the record was, that is why record was called for, my lord. From the original file was called for by this honorable court.
When was it called for? In course of hearing, we find it necessary to peruse the original file of the Government Department General Administration relating to land in question in respect of lease deed number such and such.
This land was transferred in my name in 2015.
No, it's all right. We just want to know that is the exact reason why perhaps the order was passed.
Why the consent fees was not recovered, realized from the original lessee, my lord.
Even though the transaction must have been made since at least 2015 ne jadi doctor ko na rahi thila ta purburu
so it has to be it is supposed to be recovered from the lessee. And subsequently, my lord,
why it was not recovered, what steps was taken, whether he has paid or not. So
that is why the record was called for, my lord. The file was called for.
Yes, Mr.
Kindly, they were to kindly see orders dated 38/24 and 3/9/24. On 3/9, my lords, please to keep the record in sealed cover and it's available in my lords file.
Yes, my lord. It is.
We had called for the original file, so on so forth, very well. To ascertain the real state and find out the reason for which the consent fee and so on so has been learned national person to the has produced the set by large brother. He has also verified the same. However, during the course of hearing, since we applied the subject matter, no, ये तो assignment ही गला. अपन जो verify कले कौन देखिले? अपन पुनी दे दे लेके हम. मैंने कोर्ट को दे दी जाने.
It will be registered, not by the report settlement. Is kept.
अच्छा. अपन verify करो, verify करी कि नहीं देखो तो कारण का कौन है चीज. Otherwise, so can it be taken up? Let us say weekly list. We can take up after 2-3 days from this weekly list. In the meantime, you just verify what is the reason. And he appears to be the third person.
Yes.
Oh, so
On
26th. अपन कोर्ट आवर परे अपन जो देखी देवे
kindly reflect that.
हाँ as per the order dated 3/9/2024, the London Counsel for the State produced the original file number LS95/GA-2 2007 फाइल नंबर टा देखि दो से नंबर टा ठीक अछि तो हला ऑर्डर रे लिखा है ना concerning GA plot number 159, unit 3 Bhubaneswar. ठीक है. the Land Council for the state seeks permission to verify the said file. The registry shall allow the Land and Additional Government Advocate, Mr. Mishra, to verify the file. And after its verification, the same shall be kept in sealed cover with the Land and Register Judicial, which will be produced on 26th of September 2024, when the matter will be taken up for admission. ଆପଣ ଆଜି ଦେଖି ଦିଅନ୍ତୁ
It will come in supplementary list.
Supplementary.
Item number 8.
In 8th matter, that's of cases matter telling the land acquisition notification in favor of the for construction of Nalpur railway siding. In second and third matter, I have already been taken notice and counter not yet been filed in the two cases. So far, the item number 1 is concerned in IA at flag C, mallards are directed to obtain instruction. The state has filed the instruction.
You are appearing for whom? You are the
petitioner.
You are the petitioners.
In all the batch of cases,
Okay, just a minute. As per the order dated on, Land Council for the state has received the written instruction from Land Acquisition Officer Hon'Ble dated so and so, and a copy of the same has been furnished to the Land Council for the petitioner in court today, who takes some time to go through the same. Written instruction is taken on record. It is stated that similar matters so and so. So what do you want to now?
I want I for the restraining them to for digging work from the digging work inside the petitioner's land mallet, because the here mallet kindly seen flag E. The state has admitted the position that one LA case 3 of 2006 was initiated for the acquisition of land in favor of Kalinga Coal Mines Limited in 2006. LA 3 of 2006.
No, after going through the written instruction which you have filed by the State Council, whether you intend to file anything or will hear
that I have already filed it flag F mallet.
What you have filed?
Reply affidavit.
Reply affidavit. I have filed.
And given a copy to the State
Yes,
Council?
ma'am.
Okay.
Copy oh,
a copy so that it can be taken off next week. It can be the Land Council. It appears like that after.
Am I permitted to take notice mallet in the all these cases mallet, and that they have not yet entered appearance of number 6, or even if they are in office, as I avoided to take notice.
First solve your reply.
I am for Nalco. There are 6 items. In sub item 2 and 3, I have instruction to appear.
Just a minute. Yes, in the item number 1, the State Council has accepted notice, or you'll accept. That is for 1, 2, 3, 4, and IDCO ki appear kari.
Notice nature by speed post.
That
has been gone, but no.
Okay, so far as Nalco is concerned, you are appearing. Okay. You have filed your appearance memo.
Today I got the instruction to.
What happens mallet? While the matter is here pending mallet, they have pursued digging the earth mallet. So I pray mallet. Let the status co be.
Have you received the copy of the petition?
No, that's not with me. Only
notice has gone. Notice has gone to him by speed post.
Long pages.
That you have instructed to appear that after getting the
copy so that I can take instruction at the earliest.
Why are you not filing your wakalatnama?
I got it by WhatsApp, but that cannot be used to it. Hard copy
I have given the notice by speed post mallet. Person to mallet's direction.
Okay. The reason that I got the wakalatnama in respect of sub item 2 and 3, but that is by WhatsApp message. So that hard copy I expect within a 2 days.
Then we take up this matter next week, and you got the, and also you give the reply affidavit to the Land Council for the state as well as to the Land Council. Hello, please give
hard copy.
So and so.
Niranjan Panda one.
Second, third matter, my lord, notice.
Just a minute. Mr. Niranjan Panda,
Second and
item 1, submits that he has instruction to appear for opposite party number 6 and 7. And he will file his wakalat nama during course of this week. During course of this week. The Learned Counsel for the state submits that copy of the reply affidavit filed by the petitioners to the instruction dated 28/8/2024, filed by the opposite party number 3 S.K.Sahoo Hon'Ble is served on him. Let a copy of the same be served on the Land Counsel for the state. So also Mr. Niranjan Panda 1, Land Counsel appearing for opposite party number 5 and 6. The name of the Land Counsel for the opposite party number 5 and 6 be reflected in the cause list and so, right?
But except these two items, we may solve other copies of other items so that it will be easy for me.
In item,
You will make a submission in item one. Item 1, I have no instruction.
in first item and the last 3 items, I will solve copy to him.
In first item, notice has not been issued.
Not been issued.
Sure.
Neither in first item nor in
Just a minute.
4, 5, 6.
No, we are under the impression that notice has been issued.
দুইটারে সুইচ না তিনটারে
আচ্ছা তাহলে এইটাও লিখে দিও ফার্স্ট আইটেম রে ইস্যু নোটিস অন দ্য question of so and so. After state council accepts notice on behalf of the opposite party number so and so. Extra copy to be served. After declaring Mr. Niranjan Panda 1, submit that he will file the number. After let a copy of the writ petition be served. Land Counsel for the state serve.
Madam, I say extra copies because
6 and 7.
6 and 7. So let him solve 2 copies. So
Yes,
that
ma'am.
Two copies for them. On the Mr. Niranjan Panda. This first item the issue notice on the whatever notice issue is
Second, third, our last 3 items I need.
4, 5, 6.
4, 5, 6.
Issue notice ta mane karibe
1 and 4, 5, 6.
1,
4,
5, 6. एगुड़ाक इश्यू नोटिस करिवे आ जो मझिरे 2 3 टा ऑलरेडी नोटिस इश्यू हे जाय आ सब थरे आसीबो ना आसीबो यूनियन फंड ना अपोजिट पार्टी नंबर 5 and 6 हला जो थरे इश्यू नोटिस करतंती आदरे डायरेक्शन रहिला जे समाज रिट पिटिशन कॉपी सो आल्सो रिप्लाई एफिडेविट कॉपी देबे काफी state council को so also the council for the and all these matters should come next week. Yes. And names of Mr. Panda shall be reflected in the court. Right. Yeah.
Next week, my lord, for orders for hearing my interim prayer.
Yes. Next week it will come under the heading of this admission. We can dispose of. Yes.
But let the status quo order be passed, my lord, because the possession was just handed over in 2009.
Let him come next week.
Item number 9.
Okay.
Item 9, my lord. The lordship says directed to obtain instruction, my lord. That instruction is not, my lord, made for next week, my lord.
Just a minute, let us see that order.
There is an order dated that
12/8/24.
10/9 to
For a direction to the opposite party to release the arrear salary of his father.
Because as per verbal instruction, my lord, he has paid, my lord, from 2001 to the but I have to take written instruction, my lord.
On failure of the implement order, so on, so he finds that on the ground of delay in approaching the tribunal, the original application has been dismissed. The arrear salary of the father of the petitioner for the period from Swans who was claimed in 2020. The Land Counsel for the petition submitted them in the original application. The petitioner has explained as to why there was inordinate delay in approaching the tribunal. However, he has not annexed the copies of the original Swans.
My lord, order dated 10/9
10/9.
10/9/2020.
10/9.
10/9 na 10/9.
Difficult
Last order.
10/9 is not good. So last order mote list to asu nai bodhe. Scanning file.
No, scanning for not the problem. 10-9 order. Scanning to the 10-9-24 on order has been passed.
ସେ ଗୋଟେ ଲିଷ୍ଟରୁ ଯାଇନି ଲିଷ୍ଟରୁ ଯିବା କଥା
10-9-24 adjudication here at 25. Why it has not gone?
ସେକ୍ସନ ଫେରିଗଲା ପରେ ତାକୁ ସେ ନେଇଯିବା କଥା
N9 कौन order pass?
Directed in portions of the order dated 12/2024. On counsel for the petitioner has filed the original application, solves the miscase for condonation of delay. Filed before the London Central Tribunal. Copies of same have been sought upon Mr. General and Central Government Counsel. Reviewed the original application, solves the miscase for a condonation of delay. When a query is made to the London Central Government Counsel as to why the arrear salary of the left other of the petitioner for the period from 1/12/1999, 1/12/1999 to 36/2002 was not paid. And counsel seeks for an adjournment to obtain instruction.
To what instruction go?
Instruction, my lord, he stated that from 2001 to 2002 they have paid, but there is verbal instruction not any from my lord. So I pay for some time, my lord.
Now let's go through the book response. The file laws will be operating. We are signing the order where it is. By evening, all the orders are signed, and the matter is coming after 10 days, and this is not done. So we go for an explanation.
Concerned section officer is also like sitting behind this. In almost all cases, they are not attaching the record. Earlier, it's never happened. But a periodic person attach koriya katha. Registered judicial to part in order that all the up-to-date records be made up to date.
The order which is available with us last order
Dated 5/9
is 5/9/2024. Order number 2 dated 5/9/2024. However, it has been brought to our notice by the London Counsel for the respective parties that on order number 3 dated 10/9/2024 has been passed thereafter. The same is not available on the board. Let an explanation be called for.
section superintendent at a list erakahara chiskara the read section superintendent
of the
division
read section has to file the latest order dated 10/9/2024 has not been scanned, and who is responsible for the same. Put up this matter next week, that is on 30th of September 2024.
If the amount has already been paid, it can't have be.
I have to, my lord, yes,
You can know it. It must have come to your account.
yes, I will.
You can also verify.
I also submit the written that will my lord.
That is all right. But he can also know.
However, the London Central Government Counsel, Mr. Jena, submits that as per the order dated 10/9/2024, he has received a party losses mention DSJ Mr. Party.
DSJ Party is
Mr. Party
both.
And also Mr. Jena received oral instruction that the arrear salary of the late father of the petitioner for the period from 1/12/99.
No, that is 6/10/2001 to
6/10/2001 TO2
36/2002.
36/2002 has already been paid. However, he seeks some time to produce the documentary evidence in that respect. They let the learned counsel for the petitioner also obtain instruction in that respect. The foot of this matter on 30th of September 2020.
Published.
Item number 10.
Item number 10, my lords. I pray for liberty to take all pleas before the learned DRT. My lords, no admit me to the case.
Mr. Biswal is present for Punjab National Bank.
But he was present.
Acha. So and counsel for the petitioner seeks the permission to withdraw the application. Since there is alternative payment is evident, he wants to approve it. Accordingly, the petition is disposed of. Or Mr. S.K. Biswal for Punjab National Bank. Yes.
Well, it's subject to your lordship's approval. May I place one fact before your lordship?
No, sorry. Yes, he wants you withdraw means withdraw.
All right.
Next item number 12.
Item number 11.
May I please, your lordship, my lord, kindly take off next to me.
Any order was passed at the end.
My lord,
Coordinate by single bench was there.
The learned counsel for the petitioner seeks for an adjournment until next week.
next week.
Item.
Summarized.
Item number 12.
May I please, your lordship. Main ground for challenge of the learned cat order that without serving notice to the petitioner who was the respondent number 4 before the tribunal, order was impugned, order was passed. Your lordship last occasion directed the report could be called for from the register cat.
My lord, I have got the instructions to appear the private opposite parties. Who is the legal?
Just a minute, let us go. Let a report be called for from the register central administrative tribunal. So also as to whether the notice on the respondent, petitioner respondent number 4 has been made sufficient or not, and if so, on what date, and whether any learned counsel appeared for respondent number 4. Asira report.
My lord, your lord, the report is placed.
Okay, the report. In compliance with the order dated so and so, and with kind attention the records of disposal of the instruments and the service are verified and details of which are in once to approach this tribunal in way number so and so, filed on seeking direction to the so for sanction of family pension in our favor by quashing the order of rejection dated so and so. As the legally married wife of the deceased, late Kongana Mali, retired while working under them as senior accountant and died as a pensioner. Besides the official respondent, one so and so was also added as one of the respondent number 4. Also, this is directed to this one. S.K. Sahoo Hon'Ble advocate appear behalf of the official respondent. On 4 also as per the records, notices were sent by speed post to all the respondents, and to respondent number 4. Also, the matter was listed before the joint resolution completion of bidding, which was urgent. The matter was listed before completion of urgent.
He did not answer whether it was made sufficient.
But none appeared on behalf of this one. None appeared means whether the notice
is sufficient or not.
Notice जाए जैसे appear कहीं करना है.
No, where is our query was that whether this notice served was made sufficient by the court. Once it is made sufficient, then comes the completion of pleading. Whether anybody
Notice was sent by speed post, my lord.
all right,
but speed post, but you should have
unless the return as unserved.
There is a track report, madam. The track report should have been obtained from the postal department as to whether the notice has been served or not. Because his case, your case is that the notice has not been served.
Not made
So,
sufficient.
and that is the exact reason why we called for the report. Just it is mentioned that non appeared, but once the notice has been made sufficient, it's all right. But
unless notice return as unserved, it will be deemed that notice has been
you are
served.
right in that. That is General Clauses Act Section 27, you see.
Yes.
But
But
again,
in
you
that
have
case,
to
it
prove
has to
it
be
that
yes.
it was properly all this addressed, dispatched, all these things. So
No, court only presumes an order passing sufficiency has to be there because it is deemed.
Yes,
So it has to be made sufficient.
Yes.
order has to be passed to that effect also, right?
I am the legal married wife and I have every right to get the pension.
No, that's why we are not.
So you are entering appearance for the.
Today I am entering the appearance.
Alright. So have you filed your VNAMA?
Today I am.
Please. And who is to appear for the other opposite parties?
For the 1 to 3.
Mr. Patori.
1 to 3.
Last occasion they already appeared.
Just. This Purnima Mali is opposite party number 4.
Yes, ma'am.
And the applicant before the tribunal.
She is the legal married wife.
Right.
No.
We are not entering. Think down. Mr. Nirmal Chandra.
Nirmal Ranjan Ratre.
Nirmal Ranjan Rautre and his associates have filed power for opposite party number 4, Purnima Mali. In court, the same is accepted. The Land Counsel for the petitioner is present. So also Mr. Sudhir Kumar Patra, and Standing Counsel, Accountant General for opposite parties number 1 to 3.
1 to 3.
1 to 3. So you have received the copy of the writ petition.
I will stop.
No.
I will stop.
I have not received.
A copy of the writ petition along with all the annexures and copy of the interim application be served on the London Council for the opposite party number 4.
Tomorrow.
By tomorrow. Put up this matter. Next week it will be council.
Okay.
Dedicating the name of the London Council for the.
Because of the minor impugn order, they extended the pension to in favor of OP4 minor.
He will finally adjudicate name of the London Council for the opposite party number.
Unless your lordship interim order, he will get my. I am the only legal married wife. Date.
That is
Date.
city. We are just coming with it. That's something.
Lordship said.
Special notice for judgment WBC 6405 of 2011.
In normal circumstance, the mandate of taking a prior approval or referral would have been proper. However, in the petitioner's circumstance where the patient's survival was hanging on a thin string and the fact that he was admitted under emergency circumstances reinforces his eligibility for full reimbursement. The mandate does not commensurate to a situation wherein the patient requires an urgent medical attention as it is opposed to the principles of welfare-driven public policy. Such exigencies demand for immediate and appropriate medical intervention as the well-being and survival of the patient are of paramount consideration. The state cannot adopt a mechanical approach to deny legitimate claims based on the name of the hospital or the minor procedural lapses, especially when it is proven that the treatment was life-saving and supported by verified medical records. In this context, denying the petitioner's claim for full reimbursement reflects an out-and-out technical approach. In the light of the circumstances surrounding the petitioner's medical emergency, it is clear that the minimal reimbursement amount of rupees 39,330 sanctioned by the OP number 1 and 2 is grossly inadequate when compared to the actual costs incurred by the petitioner. The petitioner followed due process by filing a referral request, and the lack of response from the concerned authorities exacerbated his critical situation. Furthermore, the emergency provisions under the 2014 government resolution explicitly allow for treatment in referral hospitals in such cases without prior approval. The treatment he underwent, which included immediate surgery, was necessary to save his life. Given these facts, the petitioner's claim merits a more compassionate and holistic view for full reimbursement rather than mechanically following procedures. The minimum amount sanctioned does not reflect the severity of his condition, nor does it consider the actual costs he incurred to ensure his vital treatment. In view of the principles of fairness, the emergency nature of the situation, the treatment provided, and the government's obligation to provide adequate health care to its employees, the petitioner's overwhelming medical expenses should be reimbursed fairly and in full, allowing him the full benefit of his entitlement within 2 months. In the light of the above discussions, this writ petition is allowed.
I agree.
Item number 13. Item number 14. Item number 15.
No, the respondent bank. Last occasion also nobody had appeared in this matter was before this honorable court that month, 2 weeks before. It may not be taken
That is 13-4 notices in Chennai.
That is all this matter.
One appears for the petition. Run counsel for the Cavator Bank of India, Mr. Syed Asif Ali, is present. On 12/9/2024, also nobody appears for the petitioner. the petitioner has challenged the notice dated so under Annexure 4, which has been issued by the bank in booking provision under Section 13(4) of the Surface I Act. Since alternative efficacious remedy is available and one appears sponsor, this writ petition stands dismissed. Yes. Obliged.
Item number 16.
Item number 16, Your Lordship, all are covered matters under Annexure 2.
Annexure 2.
Any change is to be made, only that case number, etc. There is.
Yes, Your Lordship, case number and the date.
Rest of the things, this WPC number perhaps will be changed.
Yes, Your Lordship.
Okay. बाकी सब समान रहेगा, सिर्फ के थोड़ा चेंज होगा देखिएगा. The third paragraph पे जो judgment and order dated अच्छी सेट अब the change होगा. So why don't you file given a list that what are the changes to be made in each of this, that what would be the case number? Just put WPC number so and so, LAR case number जगह ये होगा, order number जगह ये होगा. WPC number just give it in that way so that it would be easier.
I'm sorry to interrupt, my lord. Item 13 is urgent, my lord, will not appear passed out.
13 just we have passed over. We can take matter now if there is no problem.
13 and 14 also.
Yes, please argue here.
Item 13, my.
Yes.
This is a case it has been challenged by the railway on the sole ground that it is admittedly husband was died, that wife was getting all pension. Now the question is the medical assistance. Unless until he is not included in the scheme, she cannot entitled to get any medical benefits in this regard. This is the circle of the railway. But even though the counter has been filed before the Land Central Tribunal, and Land Tribunal passed an order that he is entitled to get it, against which you have preferred to file the writ petition. Now question is that, let's come to the page 38, Annexure 3. Grant of, let's got it. Grant of fixed medical allowances at the rate of 100 per month to the railway pensioners, family pensioners, clarifying that. Subsequent, I'm reading matter. Subsequent to the issue of board of letters such and such dated 7/2/2008, references were received from the pensioners, family pensioners, and bank seeking clarification as whether the petitioner family pensioners who are member of RELHS and availing UPD facility or the eligible for the fixed medical allowances. The matter has been examined and referred to the board letter such and such. It has been clarified that since the actual enrollment under the health scheme is not mandatory, those pensioners, family pensioners who in term of board letter such and such are eligible to become the member of the scheme, but are not actually enrolled, are also entitled to grant of fixed allowances for medical plans. Petitioner family and pensioners who possess RELHS and card and avail UPD facilities are not entitled for fixed medical allowances, whereas those who have RELHS card but do not avail the UPD facility except such and such, letter and such and such, are entitled for a fixed medical. This is the only discrimination. Because he has not possessed the first line one, my lord. That's why we are not able to enter. He is not entitled to get it.
No, just come to the influenced order, Mr. Padi. Yes. That paragraph number 7, just.
Yes.
That is page number 35. This
35.
Page 30.
It is
34, 35.
34. Yes.
Paragraph 7.
Yes. From the above guidelines of the scheme, it is clear from the para 3 that no actual enrollment under any health scheme is as insisted by the respondents in the counter is a prerequisite for grant of fixed medical allowances. In para 4, it was mentioned that in case of existing pensioners, the pension disbursing authority shall obtain the option and the undertaking, and based on that medical allowances shall be paid. No documents has been produced to show that the pension disbursing authority had done so. In case of mother of the applicant, while she was alive, or when she the family pension was pensioned in favor of the applicant. May I read, madam?
Yes, please. And she had decided to opt out of it.
Yes. However, it is also clear that from the para 9 that those obtaining for fixing the medical allowances are not entitled to receive treatment as outdoor patients, and only those pensioners who are members of the existing health card scheme can receive treatment for chronic disease. The applicant or her mother have never opted for any scheme or made any contribution. Therefore, the prayer of the applicant for issue of a medical card is not valid. Then para 8. Further, it ought to relevant to quote such and such where the clarification was issued for a grant of fixation of medical allowances. Subsequent to the issue of board letter such and such dated to the appearance where they received from pensioners, family pensioners, and bank seeking clarification as whether those pensioners, family pensioners, who are members of the RHS and availing OPD sheets are also be eligible for fixing them. What I am read my lord this letter that was quoted here.
Yes, then you come to paragraph number
9.
9 and 10. Those are the final parts to paragraph.
And where perusal of the above order makes it clear that actual enrollment under the health scheme is not mandatory for grant of FMA. It is also abundantly clear from the para 3 of the above quoted RV number 160 of 2009 that FMA and FMA arrears would continue to be paid to the pensioners or family pensioners only after submission of the undertaking from the pension disbursing authority, thereby implying that the fulfillment of two conditions, the pensioners, family pensioners is residing beyond 2.5 kilometers from the nearest health unit, and the pensioners, family pensioners is not availing the OPD facilities are mandatory for becoming the admissible of FMA. In case the applicants are
in case of the applicant.
In case of the applicant, the respondent should have looked at only those two conditions to see if she is eligible to FMA, and if found eligible, so she not only is eligible to get FMA but arrears of it too. The respondents says insistence on her being part of any scheme for eligible to FMA is found illegal and without due application of mine. Therefore, the impugned order is quashed and set aside. The respondents are directed to grant fixed medical allowances in respect to the subject. The applicant, the applicant from the date on which she was sanctioned family pension.
Yes.
So what is our submission? We have filed the counter and also annexer what I am cited upon to the my lord. Page 34. Let's see. Sorry, 38. That paragraph 2. I am coming to the paragraph 2, 4 lines. Scheme, but I am eligible to become the member of the scheme, but are not actually enrolled, are also entitled to grant of fixed medical allowances. Then, my lord, the petitioners, the petitioner family pensioners who possesses
No,
RELHS
pensioners oblique family pensioners.
yes, who is a case of family pensioners. Her daughter is claiming.
Yes.
Who possesses RELHS card and avail UPD facility are not entitled for fixed medical allowances. Whereas those have possess RELHS card but do not avail UPD facility except in case of chronic disease and different boards of letters and such are entitled to fixed allowance. Because this is the circular for which we are not able to calculate.
So
her mother is not contributed. He's her basing on her mother. She's getting getting pension because she's a divorcee.
Union of India is fighting like this. For 100 rupees per month, Union of India and Mr. Paddy is arguing.
Matter of principle, my lord. It's not a matter of 100 because
ସେଠି ହାରିଲେ ପୁଣି ତା against ରେ ଆପଣ ରିଟ୍ ଫାଇଲ କରିଛନ୍ତି।
ଆଜ୍ଞା ସେଟା ନୁହେଁ, ଏଟା it is a matter of only the railway is impacting all ମାନେ is open a floodgate. That's why you are
no. The two aspects that you need to ponder into in the case have not been taken care of. That is the only thing.
Here is the case. If her mother can contribute to the scheme, then definitely you will get it. She will get it. Here is the case she is not getting. That's why.
Or the party episodes agenda. This writ petition has been filed by the Union of India, represented through Swansu, and Divisional Railway Manager, Southeastern Railway, challenging the order dated 28/8/2023, passed by Land Central Administrative Tribunal, Cuttack Bench in OA case number 40 of 2020, in allowing the original application filed by the opposite party, Haramani Behera. Passing the order number Swanso, dated Swanso, passed by the Senior Divisional Personnel Officer, AC Railway, Kharagpur. And directing the petitioners to grant fixed medical allowance with monthly pension to the applicant with arrears from 11 to 2010. And also the prayer for issuance of necessary medical card in favor of the applicant for appealing the OPD facility from Railway Hospital as per rule. It appears from the factual narration that the opposite party, Haramani Behera, the daughter of deceased railway employee, who is in receipt of family pension after the death of her mother since 12/10/2010. And on coming to know that the Railway Board circular dated 21/4/99.
Lordship may refer to O, ground O, who have narrated everything. Page 23.
Regarding grant of fixed medical allowance if the pensioner oblique family pensioner resides 2.5 kilometers from the railway hospital and do not avail the medical facilities. He submitted her representation on 21/9/2019. And since the same was not considered, she filed original application number 288 of 2020, which was disposed of on 3/12/2022 with a direction to the petitioner to consider the said representation and to pass a speaking order. And thereafter, the senior divisional personnel officer SC Railway, that is that is petitioner number 3, rejected the claim of the opposite party by the order dated 21/12/2021, which was imposed in the original application. The petitioners filed their counter affidavit, and it is indicated that since no RELHS card was issued in favor of the opposite party, therefore there was no question of grant of fixed medical allowance in our favor in terms of RV number 168 of 2009. It is the further case of the petitioner that the widow of the deceased employee, that is the mother of the applicant, a mother of the opposite party, had not opted either of the health schemes, that is RELHS and RELHS 1997, by depositing the contribution as per the rule as applicable, and therefore she was not eligible for medical facilities under RELHS and not for FMA during her lifetime. And since the mother of the opposite party did not join RELHS, she was not issued RELHS card. It was, according to the counter affidavit, it has been clarified in the RBE number 69 of 2014 that in cases where existing pensioners or family pensioners were in receipt of fixed medical allowance, the family pensioner next in line may be allowed the fixed medical allowance from the date from which he or she becomes eligible. A RELSH card and an eligible member for getting medical facilities under Railway Health Scheme is prerequisite for eligibility of fixed medical allowance in lieu of opting out of OPD facility. It is highlighted in the counter affidavit that since neither of the conditions for eligibility of getting the fixed medical allowance fulfilled in the case of the opposite party, her case was rejected. The opposite party filed a rejoinder wherein it is highlighted that her father died on 16/6/1967, and family mention was sanctioned in her mother's name since then. And since her mother was an illiterate lady and she did not know about the said scheme, she never opted for the same and never was issued with medical card or fixed medical allowance. The learned tribunal took into account the relevant portion of the fixed medical allowance provision which was introduced in the railways by RV number 65 of 1999 and held as follows. Quote paragraph number 7. The learned tribunal also took into account the RV number 168 of 2009 relating to the clarification for grant of fixed medical allowance and came to hold as follows. Quote paragraph number 9 and 10. Mr. Padil and Deputy Solicitor General challenging the impugned order passed by the London Central Administrative Tribunal drew the attention of this court to Annexure 3, which is dated 15/9/2009, passed by the Deputy Director Pay Commission Swanso Railway Board, wherein it is indicated as follows. Quote from paragraph 2 and quote 2 and 3. The Land Council submits that in view of the mandates as mentioned in Annexure 3, the London Central Administrative Tribunal was not justified in granting relief to the opposite party, and therefore the impugned order is liable to be set aside. After hearing the Land Council for the petitioner and going through the impugned orders, also the averments taken and so on, and the analysis made by the London Central Administrative Tribunal, we find that the London Tribunal has arrived at a right conclusion and in setting aside the order passed by the opposite party number, petitioner number 3, on dated 21/12/2021. Therefore, we are of the view that there is no illegality or infirmity in the impugned order passed by the London Central Administrative Tribunal. Accordingly, the writ petition being devoid of merit stands dismissed. Same order in the other.
Along with me, Mr. Guchayat appearing, let's repeat.
Mr.
Deepak Guchayat.
Deepak Guchayat from now.
Deepak and CGC.
Yeah.
Item number 17.
May I please, your lordship?
My lord, thereafter 114 is there. Let's make next week.
So you said it is similar matter?
No, it is a different matter.
It's a different matter.
We took it as similar.
Acha. That means 14 is similar matter. So 14 when so on so 6 for an adjournment. Yes. Yeah.
Item 17.
May I please, your lordship? I am in BC. May I be permitted?
Yeah.
Lordship, this is a matter relating to acquisition of land for Raurkela Steel Plant, wherein no compensation has been paid. And if your lordship will see, the petitioner has made representation to ADM.
Your prayer is
in Annexure 5.
And it's a
Annexure 6.
6. So
Yes, sir.
it is pending since 13 to 2024.
13 to 20.
You have not
Yes,
received
sir.
any response from the authority.
No response from the authority.
And Annexure 6 is to be disposed of. See, usually 3 months time from the date of launch and order to be communicated within 15 days. All right. Yeah.
Grateful.
Item 19.
Item number 19, I'm appearing on BC.
Okay.
Yes. Item number 19, I may be permitted to withdraw this application with the liberty to approach the appellate committee of this honorable court.
There are 2 writ petitions. Both you
Yes,
want to
yes,
withdraw.
yes, both.
Grand Counsel, so and so. 6 permission to withdraw the writ petition. The both, dispose of or withdraw, all that.
Item number 20.
But wait, Your Lordship. The last occasion, if I still remembers, the bank had entered appearance actually to 10 years.
Yes.
But here, order that has been passed, that is 37/2024, which is the subject matter of challenge. But I am conscious of the fact that the scope to interfere in these matters before the Honorable High Court is very, very limited. But even Your Lordship the other day indicated that a judgment has been circulated of the Supreme Court to all the courts, indicating that not to interfere in these matters, where a special statute is provided for the purpose of adjudication of the dispute.
Because earlier they were passing the order in
Since 2010,
so
number of judgments have come, but there is a catch, in fact, but their Lordship do not outright reject the application which is filed for the Honorable High Court. But if the provisions are there to challenge, then obviously the Honorable Court directs that you go to the appropriate forum.
No, what happened, Mr. Mishra? The last order,
yes,
which has been in that Annexure 20 is the impugned order.
Annexure 20 is the impugned order.
The last order is 37/2024.
Yes, madam.
So almost 1.5 months have passed in the meantime.
Yes, I have challenged that. Which is pending for your Lordship, madam.
No, any development made after that?
Sir,
possession taken.
Possession has been taken over.
The property has been sold also.
So that is exactly my point.
So now you have to go to the other side. We are saying that perhaps this is lying at that stage. No, nothing. So by virtue of the order passed, the possession has already been delivered. So what can we do?
Here, one thing actually, Your Lordship, can see. My friend says that it has been sold. Nothing has been communicated to me. The statutory
that ground, Mr. Mishra, you can very well take in the appellate forum. So
they have disclosed. They have sold to whom they have sold in
all public auction is there. Paper publication was there.
No, sir. So law says if Lordship looks at Rule 8 and Rule 9.
But what is the role of the borrower vis-a-vis Section 14?
Sir, Section 14 says, if Lordship looks at the decision of Justice, okay. No, wait, I'm not how it is High Court. Sing some better. Section 14 actually, the scope of hearing is not there. But the Section 14 is only the provisions of the 14 has to be complied with.
Yes.
The affidavit has to be filed and the affidavit must contain the details of requirement that is there.
So it is between the bank and the authority.
Bank and the authority. Well, that was, I also challenged that in before this Honorable High Court. The Honorable High Court has passed an order. The decision of Me sitting with Sir Raman. Justice Jaswant Singh, sitting with Justice Raman, has passed an order, my lord. There it is specifically mentioned that keeping in view of Rule 4, before possession is to be taken, the party has to be noticed. 15 days notice has to be given. Here that 15 days notice also has not been given.
60 days.
No, 15 days notice.
15 days notice. Prior to that, 16 days notice. That is complied. 60 days notice has been complied, has been mentioned by the CGM. That has been complied.
So judgment is still available. Judgment.
That is
Sir, volume 2022 volume 1 whether plus 521. Let me kindly have a look. Judgment still recorded. Justice Jaswant Singh has passed an order. Jaswant Singh's judgment against. I'll just 1 second, but I'll give it.
So, Mr. Dey, this after you took over the possession, then you have already sold the property.
Property has been sold in April now.
April.
The certificate has been issued as back as on
Just a minute.
5/4/24.
April 2024. Sell certificate issued.
Act again.
So, at this stage, writ petition, how do you say, Mr.
Sir, here actually this is a case.
Are there. Recently also, this Justice Chandrachud says that don't, once the even 13-4 said that you stop entertaining this, and here
Sir, this is one of such instances where the outstanding was 1,92 lakhs.
So the appropriate forum.
But I had offered the entire amount I'll pay.
Now that man is to be made a party. So many things you have to do appear before.
But they have not given details about the sale. Let them file an affidavit, man. When it has been sold and to whom it has been sold.
Take that instruction by filing an application, and that will be provided to you and challenged before the appropriate forum.
They have not provided that, man.
The petition has been filed by the so and so Freya for setting aside the orders.
Well, can I just submit one thing, Malad? Mercy permit me, Malad.
Yeah.
But if your lordship looks at Rule 9, Malad.
Yes.
Item 1, sub-rule 1, no sale of your property.
Yeah.
Unless under these rules, in the first instance, shall take place before the expiry of 30 days from the date on which the public notice of sale is published in newspapers as referred to the proviso. So, rule 1.
Of which rules?
The Security Interest Enforcement Rules 2002, Malad.
Yes.
Rule 9, Malad.
Rule 9.
Yes.
Yes.
Time of sale, issue of sale certificate and delivery of person, etc.
That according to you has been flouted.
So, if you actually look at Matthew Fergus says that or has to be read as and. This last sentence, no sale of real property under these rules in first instance shall take place before the expiry of 30 days from the date on which the public notice of sale is published in newspapers as referred to in the proviso of sub-rule 6 of Rule 8, or notice that or is and merit of sale has been served on the borrower. No notice has been served on the borrower.
That is no more open to be challenged, my lord.
No, that 13.2 was there, 13.4 was there.
All things has been complied.
challenge
No,
this
it
one.
has not been complied with.
You have not challenged it in the writ petition.
The land counsel for the bank, Mr. Day, submits that in the meantime, the possession has been taken, and in April 2024, the property has been sold and sale certificate has also been issued. Mr. Mistral and senior advocate referred to the section 9 of Security Interest Enforcement Rules 2002 and submits that notice of sale has not been served on the petitioner, and therefore there is a clear violation of the provision.
And the right of redemption remains.
Right of
redemption ceased once, my lord, the sale notice is published.
remains.
No, not.
Mr. Day
That is what
submits
the
that once the
court
sale
says.
notice has been issued, this right of redemption ceases in view of the provision that is 13.8, na?
Yeah, 13.8.
In view of the provision.
Section 13.8. That has been put at rest now.
13.8, can I just close one thing, my lord?
That is
Give permission, my lord. There's to put judgment, my lord.
This, in the case of so and so, the justice chamber should be since alternative remedy is available in the petition, we are not inclined to attend this one. So according to that. Yes.
13.8 is still, so we can't see the judgment, my lord. I'll go to the appropriate authority, my lord. So kindly have a look at the judgment. That's Selip LLP, my lord.
Yes, that is exactly it.
That operative persons at pays, I think 110, my lord. Sorry, paragraph 110.
110, so that paragraph 110.3 they say insured is.
Just reading that, my lord. Just 1 second. In accordance with the unamended section 13.8 of Sufficiency Act, the right of the borrower to redeem the secured asset was available till the sale or transfer of such secured asset. In other words, the borrower's right to redemption didn't stand terminated on the date of auction sale of the secured assets itself. It remained alive till the transfer was completed in favor of the auction purchaser by registration of the sale certificate and delivery of possession of the secured asset. However, kind of marvel. However, the amended provision of section 13.8 of the Sufficiency Act make it clear that the right of borrower to redeem the secured asset stands extinguished thereunder on the very date of publication of the notice for public auction under Rule 9.1. Am I clear, my lord?
Yes.
So 9.1 has to be complied with. But 9.1 has not been complied with.
You say that.
No, don't say that. How can I say?
That you have not said.
Once 9.1 has not been complied with, my right of redemption remains.
All right, next.
But your worship indicates I will approach the appropriate
Yes,
authority.
that is all.
Right. But only details of the sale has to be provided.
The Mr. Mr. submits that the detail of sale has been not been supplied indicated to the petitioner. Mr. Day, the counsel submit that the petitioner approaches the bank. The same can be provided.
In a period of so that I can challenge it.
Tomorrow I will provide.
By tomorrow it will be provided if he approaches.
Right.
Yes.
Right.
Item 21.
What's the recommendation for it?
My lord, in item 21, both the matter relates to the land acquisition matter.
Your representation is annexure 5.
My lord.
It is dated 23/4/24.
My lord.
You have not received any communication from
my
the
lord,
authority.
annexure 4, my lord. The proceeding has been initiated.
कौन पचारुछु आपनको रिप्रेजेंटेशन जो देइछंदी 23/4/2024 पर बेले annexure 5 ताट पर आउ किछि रेस्पोंस पाइ ना दी representation annexure 5 is to be yes similar order in the connected one.
My lord.
All right.
Item 22.
Secondary annexure 4 अच्छा ए प्रथमटा रोची annexure 5 आउ जो with ही अछि सेटा annexure 4 हैलो और देखि दो टिकट चलो
Item 22.
immediately. The second round litigation matter. What happened in this case, my lord? The
First time you ଆସିଥିଲେ representation dispose of ହେଲା direction କୁ ତାପରେ କଣ order
pass, my lord.
Next to 6th.
My lord.
ଆସନ୍ତୁ operative part କୁ ଆସନ୍ତୁ.
My lord. Last paragraph of page 21. In view of the above facts and circumstances after provision, it is seen that the case land now stood recorded in the name of Home Department with reference mutation case number 40989, appeal case number 1990, revision case number 2002, and mutation miss case number 98 of 2006. So the petitioner submit that he has not filed any appeal revision in respect of the case land in any court. He has applied. He has also filed affidavit in this regard. The Tahsildar Khorda is directed to provide the certified copy of the mutation case of the petitioner within 7 days. After that, the petitioner is at liberty to follow the due process, applying for appeal revision before the competent court. After that, I have applied, and they have stated annexure 7 that the case record is not traceable. Again, I have filed an application before the collector, my lord, advance that your order not complied, and I am not getting the certified copy, my lord.
What happened there?
Well, this is pending.
Acha. All right, we will direct the disposal of this petition. The learned counsel for the petitioner submits that in the first instance, the petitioner approached this court in WPC number 222-22206 of 2023 by the order dated 19/7/2023. The writ petition was disposed of with a direction to the opposite party number 2 settle kiye thile. The writ petition the same. Opposite party number 2, Collector Khurda, was directed to consider the representation filed by the petitioner and pass appropriate order in accordance with law. And as for the order passed by this court, the opposite party number 2 by annexure 6 dated 12/4/2024 disposed of the representation and observed that since the case land has been case land stood recorded in the name of Home Department with reference to so and so, and the petitioner has not filed any appeal/revision in respect of the case land in any court of law, and to that effect he has filed the affidavit. Therefore, the Tahsildar Khurda, that is opposite party number 3, was directed to provide the certified copy of the mutation case to the petitioner within 7 days. And the petitioner was given liberty to follow the due process of law in applying for appeal/revision before the competent authority. Learned counsel for the petitioner submitted that when he submitted an application for getting the certified copy of the mutation case, the Tahsildar passed the order on 30/4/2024 that the record is not traced out after thorough search, and therefore the application of the petitioner was not entertained. It is submitted by the learned counsel for the petitioner that the petitioner again approves the opposite party number 2 by filing miss case number 16 of 2023, wherein a prayer has been made to pass necessary order, but and the said petition was filed on 1/7/2024 with another application for advancing the date. Advancing the date कौन file करें?
Madam, that was dispose of issue that I filed an advance petition. That was not before the court matter.
Dates on appeal and they have to put up the case record. But no order has yet been passed. And therefore, the opposite party number 2 may be directed to consider the miscase number 16 of 2023 in accordance with law. Land Counsel for the state has no objection, considering the limited nature of grievance of the petitioner. It is observed that the opposite party number 2 shall consider miscase number so and so in accordance with law within a period of from the date of production. 8 weeks दे दो 30 days खाली तब डायरेक्शन दबागा था तहसीलदार को फाइल तब प्रेस आउट करूँ तो बता पचेरी ऊपर फाइल वाला इधर so let it be also 8 weeks 30 days 4 weeks from the date of production of the certified copy of this order disposal period.
Direct him to produce the order copy before
from the date of production of the certified copy of the order. Disposal within 4 weeks. The petitioner shall produce the certified copy of the order before the authority. That is opposite party.